Subina, just Nikhil, you log out.
Hi, Dr. Branting.
Hi, good morning, or good evening, sorry, depending on where you are.
Yeah, I'm in London, so it's afternoon over here. I think morning in your location.
Yeah, indeed.
Yeah. So let me, okay, so you are co-host now. Let's wait for a couple of minutes. Would you like to test whether your screen sharing is working or not?
Yes, indeed, that would be good. Let's see. How's that? Am I sharing the right screen?
We can't see anything. Don't know.
Let's see. Didn't succeed. Ah, here we go. And now?
No, still there is nothing. There is no screen actually which we can see.
Curious. All right, let me try again.
Okay, sure. Yes, something is happening now. I think it will start. It just shows that it has started screen sharing, but still it's.
Actually, I am able to see the screen.
Okay.
Yeah, I'm also able to see.
Yeah.
Okay. Are you able to see the correct screen?
Yeah. No.
Yes.
Yeah. Now we can see. Now
okay,
I can see
great.
everything. Yeah. So I think we can wait 1 or 2 minutes for others to attend. Then we can start.
Okay, good.
So I think we can start now. So let me first give an intro for Dr. Branting. So just a minute. So Dr. Branting is a chief scientist in Human Language Technology Department in the MITRE Corporation in USA. So he was the president of the International Association for Artificial Intelligence and Law from 2004 to 2005. And he was also United States Supreme Court Fellow from 2000 to 2001. He is also a recipient of NSF Career and Fulbright Senior Scholar grants while he was a professor at the University of Wyoming, and he has a PhD in computer science from University of Texas, Austin, and he has a Juris Doctorate degree from Georgetown University, and also a BA in philosophy from the University of Colorado. Thanks once again, Dr. Branting, for giving this talk in SAIL 2022. I think the stage is now all yours.
Okay, well, thank you so much for that introduction, and thank you for inviting me to present this work, which I'm pretty excited about and happy to share. And I hope that there'll be some interest in it and that there'll be some follow-up conversations. Okay, so I'm going to be talking about a computation model of facilitation in online dispute resolution. And so I'll define each of those things. I'll start by sort of motivating this work and talk about our approach, which is somewhat distinctive. I'll describe a discourse model of facilitation and also a decision support prototype, which I'll give a demo of it. And then I'll talk about some future research directions and some research questions that are raised by this that have come up in other times that I've presented this work. So the motivation has to do with access to justice. So in the United States, in India, in most places, poor and middle income people who can't afford a lawyer are at a real disadvantage in civil and administrative proceedings. So I'm not going to be talking about criminal proceedings. They're demonstrably disadvantaged relative to parties with attorneys, and they also disproportionately burden agencies and courts. And one approach to responding to this challenge of litigants who don't have a lawyer is online dispute resolution. And the idea that these automated systems that allow people to settle their disputes sort of remotely without having to be present in court can reduce the disadvantage of pro se litigants several ways. One of them is reducing the importance of legal advocacy skills. So it's not that the idea isn't sort of pitching to a judge or a jury, but it's rather working something out with the person you have a dispute with. It eliminates travel and time off expenses, which can often be very burdensome. There's some evidence that litigants actually learn something about how to assert their claims and defenses just from going through that exercise, even if they end up in court. Yeah, but on the other hand, access to online dispute resolution can itself, there can be some inequality there. Not everybody has a computer. Some ODR systems have been shown to sort of disproportionately benefit people with more resources. So it's not a panacea, but there's reason to believe that it can help. So delving into it, online dispute resolution systems typically have some a sort of a skilled neutral party that helps the process go along. In particular, a facilitator. And I'd kind of add as a footnote here, this work doesn't really talk about mediation. So there's also mediators. So mediators are people who actually make proposed solutions and are sort of deeply involved in generating and evaluating proposals. So facilitators don't do that. They just assist with keep the discussion from bogging down and help people understand how it is that they need to reach a solution. So facilitators, that's really what we're looking at. But even facilitators there's not enough of them to supply all the needs in ODR systems. In some cases, they're volunteers, in other cases, they're paid. And if they are paid, they're expensive. And then that sort of reduces the whole benefit of online dispute resolution as a resource for people without a lot of money. So if you had a computational model of facilitators, you could imagine using it several different ways. One of them is such a model could help the facilitators, like by improving situational awareness or helping them perform routine tasks. You could also use it for training. You could also think about having completely autonomous facilitation. But those latter two things are not our interest. We're interested specifically in this first thing. Can we help facilitators do their job better? Can we help them handle large volumes of cases, which they frequently need to do? So in this project I'm going to be telling you about, we had a key resource was a collaboration with a particular state in the United States, Utah. So Utah has instituted ODR in its small claims courts. Originally, at the time that we started this work, it was just in 3 counties, but it's extended beyond that now. So basically, in Utah, if a plaintiff wants to sue someone in small claims court, they have to go to ODR, which gives the defendant an opportunity to negotiate a settlement without going to court. And that has been shown to reduce the likelihood of a default. So we're able to get these really terrific resources. So one of them is that we got a whole bunch of transcripts of ODR sessions. And one of the reasons that this resource is so valuable is that the ODR sessions are typically sensitive. It's personal stuff. When people go into an ODR system, they're told that what they say there can't be used in court. It's private. And so you can't get public data sets of these things in general, unfortunately, which really impedes work in this area. But we were able to get this nice corpus. We also got the cooperation of the facilitators in the Utah system, who were willing to be subjected to really extensive and repeated interviews. So our approach it's unusual in that there were 2 pretty separate strands, one of them involving human-centered engineering and one of them sort of data analysis, corpus analysis. So starting with the human-centered engineering part, we initially did a pretty elaborate cognitive task analysis of facilitators to find out how they do their task. Then we shifted to the data analysis to develop a kind of a taxonomy of states and actions that facilitators, states that they respond to and actions that they take based on the transcripts and the model itself. And we were able to using machine learning, as I'll tell you, develop predictive models for identifying the state of the discourse and the corresponding facilitator action. And then when that was done, we switched back to the sort of human-centered engineering component and focused on developing a decision support tool. So we went through the exercise of finding out what aspects, what applications of the model would be most useful to them. To sum up, so human-centered engineering, data analysis, these people normally don't sit in the same room, but this was quite the collaborative effort. So I'll start by sort of summarizing the cognitive task analysis. The people who do this are called human-centered engineers. The human-centered engineers, they interviewed the facilitators. They came up with an initial sort of set of actions that the facilitators think that describe themselves as doing, and the situation that they describe themselves as responding to. And once we'd gotten that, they made a set of sort of prototypical scenarios that were similar to the case transcripts, but not sensitive. And the facilitators would be asked to pretend to be participating in an ODR session, and if a certain set of events happens, to say how they would respond. So basically eliciting in a kind of context-sensitive way how they would act. And when we did this, one thing that came out of this was that we were able to sort of break down the situations that they described as arising in these, they're pretty routine ODR cases, break it down into some basic sort of what we would call discourse states. So what's going on in the conversation between the disputants? There's kind of introductory stuff. There's sometimes they get into a disagreement, and that they have trouble getting past. Negotiation is kind of the horse trading. Agreement is sort of a tentative sort of identification of a settlement, but the agreement can turn into disagreement. But when it's concluded, we have a conclusion. We have other things like an impasse in which the parties just simply can't go forward. There's also something that we call social pragmatics. At every stage in the discourse, there's sort of thanking people, a sort of social niceties, the kind of things that you have to do if you're going to interact effectively with other people. Okay, so based on all that initial sort of human-centered analysis, we came up with this kind of model to help us do the key task is to be able to predict what facilitators are going to do. And so the first step of that is to say, well, let's make a taxonomy of the things they do, which in this case, we can think of these as speech acts. So that's something from linguistics, a speech act or an illocutionary act. That's the thing you're trying to do when you speak to somebody. If you say, can you reach the salt? That sounds like a question, but really it's a request act. It's a way of saying, I would like you to give me the salt. And in a similar way, there's many ways to express many word choices for what facilitators do, but we can break them down into these categories. What are the speech acts? What are the discourse states in which those speech acts take place? And what's the dependence? So, for example, as I mentioned before, some of the examples of discourse states are like there's a disagreement. And in that situation, one of the speech acts that facilitators do is to try to refocus the discussion. And one way they can say that is, what common ground do you both share? Or another example is that in the negotiation, a sort of horse trading, a typical thing to do in that situation is request terms. And one way to express that is, would either party like to propose a payment? Okay, so there's a discourse state, there's a speech act that the facilitator performs in that discourse state, and then there's the text. That's the actual language that's used. So I won't belabor this other than to show you that through a kind of iterative process, we developed this taxonomy of all the kinds of speech acts that facilitators were observed to perform in our corpus at sort of the level of granularity that we were able to analyze it. And there were about 25. Okay, and so the next step is that, well, okay, let me go back. So these speech acts, we want to be able to predict this. So a good model is one that in every single stage in the negotiation, it tells you what the facilitator ought to be doing. Should it be thanking a disputant? Should it be stating a conclusion? Should it be pointing out the risks of trial and asking people to refocus? So that's the place where the sort of predictive model is of value. Now, some of the things that we observed that surprised us a little bit. One of them is that the speech acts of disputants and facilitators are disjoint mostly. They don't overlap. So what I've been talking about is what facilitators say, but disputants, their discourse is different. They're talking in negotiation space. So here's a kind of a negotiation state transition diagram. So this is, you might recognize this from something like smart contracts or from going back in time. And Gardner had a diagram like this about contract formation. So it's a kind of state transition document. It's a diagram that is a kind of model for what disputants are doing. They're making offers, they're rejecting offers, accepting offers, things can time out if they don't respond, something goes to court, or if they just cannot reach an agreement, things go to court. If there's an acceptance, then they get a settlement. I hope that makes sense. So so just abstractly, the disputants are in this negotiation space, but facilitators are not in that negotiation space. They can't make offers, they can't accept offers, they can't do any of those things. Instead, they can do these other actions that are intended to facilitate transition by the disputants along these links. I hope that makes sense. So that was one interesting thing, was that in this domain, if you want to model a discourse, it really is sort of two discourse models. A second one that surprised us a little bit was that the facilitators weren't interested in getting in anything by a sort of decision support that was substituting for their expert judgment. So we thought initially we were going to be able to predict the outcomes of these negotiations based on what was going on. And indeed, we could do that. But the point is that they're not interested in that. It's not helpful to them. They can make that prediction. What they are interested in is improved situational awareness. So the facilitators, by and large, they're interacting with multiple negotiation sessions, and some of them, from time to time, it's important for them to get up to speed on what's going on and respond appropriately. So automating routine tasks, especially composing routine messages, was one that they liked. They often say highly stereotypical things in a given situation. So, if we're in a situation where the parties need to be reminded that if they don't reach a settlement, they're going to have to go to trial, each facilitator has a fairly standard way of saying that, and it's tiresome for them to type it in all the time. Okay, so this is kind of this is basically abstractly the facilitation model. So it has two parts. This is a recap of what I've described before. One part is a kind of a representation, and the second part is a predictive model. So the representation, that's the vocabulary for describing the discourse states, what's going on in the negotiation, and also what the facilitator can do. And then the predictive model basically starts with a bunch of utterances, because that's all you can observe in an ODR session. And it calculates some discourse features. And from that, it calculates a discourse state. That's the kind of high level categories I was describing, plus an action by the facilitator. And so an action is like an introduction or asking for the disputants to refocus, and then finally an utterance. So here's an example. Suppose the defendant says, "No way I can pay that much." So this is classified as a rejection. So that's the discourse action, is that it's a rejection of a pending offer. And there's all these other kind of discourse features. I'll tell you a little bit about those. Things like sentiment. There's a kind of negative sentiment involved with that. And from that, we what we want to do is to say, well, we're in the middle of negotiations. That's the sort of horse trading back and forth process. And an appropriate thing to do, given that that's the state, and we have some of these other features, the model says, well, you should probably ask a probing question. And an example of a probing question is, how much could you pay? Okay, so as I said, as at each step in the negotiation, we start with the utterances, and from the utterances, we want to figure out what the features are that are relevant to saying what's our discourse state. And the discourse state, that's going to tell, our model is going to say what facilitator action to take in that discourse state. So what are some discourse features? Well, we don't have like a perfect theory of discourse features. What we have is the things that we can observe and calculate in a sort of reasonable way. So we calculate a bunch of them, and we apply our machine learning model all these features. So the discourse features are like, well, who is it who is speaking in the most recent turn and the previous one? We turn that into a semantic vector representation of the most recent thing that got said. That's a kind of a standard computational linguistic thing. How many turns has it been since the beginning of the negotiation? So you could imagine that that's highly relevant for things like, well, if there haven't been any turns, it's probably we're in a state in which an introduction would be appropriate. If we've had a few turns, then an introduction is never appropriate. The speech act categories of the most recent disputant utterances, that's the things like a rejection or acceptance. The sentiment, so we do the sentiment analysis of the last three turns. It's basically, are things getting more positive or are they getting more negative? We calculate some other just characteristics of the discourse without necessarily knowing, are these things critical for understanding the discourse features? Well, not clear, but we want all the features that we can inexpensively calculate, we do. Yeah, and how long it's been since the most recent utterance. Okay, and so if we calculate all those features, and now we want to, and we train a model to predict the discourse state and also the action, the speech action, the speech act of a facilitator. How accurate are we? Well, to start with, we tried calculating the simpler thing, which is, does a facilitator speak or does a facilitator not speak? So you could imagine that it's like if your partner, pokes you in the ribs and says, say something. Is this a situation where that's appropriate for the facilitator to pipe up, or should the facilitator just say nothing? So, well, let's just look at this column number 4 here, weighted F1. You can see there's pretty good accuracy on that one. If we want to calculate the discourse state, it's not quite as accurate. If we want to calculate in calculating the speech act, it's just slightly less accurate. So this is what we get in tenfold cross-validation on our training set, which is based on those 6,700 instances that I described before. I would say that clearly we're able to do some prediction. Is this, could we improve this with a larger training set? Absolutely. Is this accurate enough to make a system that's really useful and that improves the facilitator's ability to do their job, or disputants' happiness, satisfaction? Well, we think so, but within the scope of this project, we weren't able to actually test the system fully. We were only able to do this cross-validation testing. Okay, having developed this discourse theory of facilitation, basically, and then trained a model that can predict what facilitators should do based on the features of the discourse state, we then circled back to making a tool that could actually support facilitators' ability to do their job. So we had a series of workshops to find out what kinds of features and frameworks they would like. There's something called a participatory design workshop in which they got to suggest their own features. Got feedback on initial design. There's various kinds of human factors stuff that isn't exactly my primary area of expertise. But anyway, in the end, we made this prototype based on the things that our human factors people told us. And so I'm going to show you a couple of screenshots, and then I'm going to give you a demo of it. Well, a recording of a demo of it. So basically, the system is accessed through a dashboard. The dashboard looks somewhat similar to the existing Utah system, but with a few additions. So one screen shows the cases that have been assigned to the particular facilitator, but it also has these kind of case status alerts. So alerts are things like, well, there's some kind of an interpersonal conflict is detected in this case right here, meaning that you need to intervene. And yeah, where does that come from? It's what I was saying about the sentiment. If the sentiment is like really going down, then people are probably starting to call names or get highly negative. So we can detect that using these pretty standard sentiment analysis techniques. Another one is inactivity. If people go too long without responding, then the case will be closed and directed to, the facilitation will end. It'll time out and the case will get sent to court. So that's something, we have a test for that as well. And then there's another dashboard which has this kind of chat window, which is very much like the existing system. But on the other hand, we have a set of suggested messages. So there's a drop-down window here that has actually corresponds to the discourse states. And if you click on it, and it shows a series of suggested, basically text based on the suggested facilitator actions. And I'll show you how that works in practice in just a second. But often happens that the facilitator doesn't want to use the standard text, wants to make their own. So we have a facility that allows them to add their own text and save it. And after that, it becomes sort of the number one suggestion whenever you're in that discourse state. We have we implemented, of course, this is all a prototype, but basically a event-driven, service-oriented architecture that can connect up to an ODR system. So it's transparent to the plaintiff and defendant. They don't see anything going on, but it presents an enriched interface for the facilitator. Okay, so what I would like to do is share a different screen so that I can give you a demo, if I can. So I think I'm just sharing that presentation. And
maybe you can stop sharing and start sharing again with the screen that contains the demo. Maybe.
Yeah, I think I need to do that. But let me see. How do I stop sharing?
I think you will see a bar above your screen in the top most position, which will say stop share.
Yeah, sometimes you may need to hover your mouse to the top part of your screen. It may not appear on its own.
Oh, yeah, I apologize for this. I've somehow or other I've minimized
Yeah.
of the screen, and therefore I'm having a little trouble finding out. Can you stop my sharing so that I can share this other thing?
Okay.
Oh,
let me
yes, of
just-
course. I'm sorry. Yes, of
Okay,
course. Stop share.
okay,
I'm just
fine.
looking the wrong place. Got it.
Okay,
Yeah, sorry.
no issues.
Okay, so now I would like to share yes, this is it. So I want to share this. How about this? Can you see the?
Yeah, it has started sharing. Yeah, we can see.
Yes, we can see it.
Okay, so it's possible you might have to turn your sound up just a little bit because it's not too loud. But yeah, this is the demo.
I'm a human-centered
Okay.
engineer on the AIDR project, which stands for Agent-Based Intelligent Dispute Resolution. AIDR augments the dispute resolution process by providing situational awareness and decision support to facilitators. Today, I'll be acting as a facilitator named Monica, who facilitates for online dispute resolution in small claims court. As a facilitator, it's my responsibility to check on the cases assigned to me every day or every other day, and to assist the disputants in these cases in order to achieve a mutually agreeable resolution. So to begin, I've logged onto the AIDR dashboard and see that I have 2 new cases assigned to me. Both cases have a few new messages from the disputants. These notifications provide situational awareness for my assigned cases so that I can prioritize my work as my caseload increases. So both urgent updates and other updates will provide me notifications on the status of each case. Each of these notifications for these cases correspond to a status that is available also in the case queue with a corresponding symbol or icon, which provides the facilitators the ability to gauge the status of a case just at a glance. I can also see how many messages there are that I have not viewed embedded in the quick link for the chat. So one of the notifications here prompts me to check on the case and send a response. So I can quickly access this case by clicking on the hyperlink title of the case of the notification. So here we can see that both the defendant and the petitioner have sent a response. So since both parties have sent an initial message and began chatting, it's an appropriate time for me, the facilitator, to introduce myself. On the right side panel, there's a tool that the facilitator can use to reduce the cognitive load and time it takes to respond in each case. Currently, facilitators have to read the chat and decide the most appropriate response. Some dispute resolution systems provide boilerplate messages to facilitators, which are used to quickly respond to disputants and reduce the risk of typos, and to also standardize messaging across facilitators at the court. So the AIDR prototype streamlines this process by using standardized messages in a dropdown of message categories for the facilitator to choose from depending on what stage of the negotiation the case is in. It also improves decision support by embedding suggestions that the system has predicted would be an appropriate next response based on the chat history. The facilitator can pick a message category, which then displays a list of messages that are available within the category. Highly suggested messages are displayed at the top of the list, as you can see here. Selecting one of these options listed in each category will populate the boiler text into the message field. The system will populate the names of the facilitator and the disputants wherever appropriate so that the facilitator doesn't have to. If you do want to edit the message though, or add to it, you can do so here in the message field, or you can just send the message as is. Facilitators need to send an initial introduction as well as a disclosure statement after both disputants have begun talking. I'll select and send that message as well from the list of available system messages, which always provides me the same list of messages every time. Now that I have sent both my introduction and my disclosure statement, I've fully addressed this case and can return to the dashboard. The other case that I've been monitoring also has a message that's available to view. Even though it's only a single message, which means that both parties have not sent an initial message, and so I should probably hold off on my introduction, I would still want to check the case just so that I am aware of what's going on. So I can see here that the defendant has sent a message saying that they don't agree with the claim And actually, while I was in the chat, I just received a message from Kelly, who said that she is arguing with Bill, and it's time actually for me to introduce myself as the facilitator, since both of them have began chatting. So since this is progressing quickly, I would want to choose the introduction message that is suggested by the system, but I may also want to tweak this message so that it is fine-tuned to this case or this context. So we can see that Bill and Kelly are escalating their disagreement just a little bit. So I would want to let them know that if either of them feel the need to talk privately with me, that they have the option to do so. So I want to say in this message, either of you wish to speak privately, please let me know and we can chat individually. So let's say that I wanted to save this message so that I can actually use it later in similar contexts when both disputants have sent an initial message, but have begun to maybe argue a little unproductively. So I want to save this as a standardized message. Here you can see that it automatically populates the message type from the dropdown, which is what I would want because this is technically still an introductory message. And here you can see that all of the message text that was available in the message field has been populated. So I can edit it last minute, or if I think that it's sufficient, I can save it. And then you can see here that my saved message is now available in this right side panel anytime that I access introduction and disclosure statements. I've decided to return back to the AIDR dashboard to check on the case statuses and read any new message after a couple of days have passed. I can see that there's an urgent update for Bill Serino versus Kelly Ramon. It's stating that there's an escalating conflict that was detected in the chat. The system measures and detects negative sentiment of the conversation in order to alert a facilitator that disputants may be arguing unproductively. This way, facilitators can prioritize cases that might need more assistance over others. As you can see, the plaintiff and defendant are arguing in a manner that isn't necessarily productive. In response to this, the suggested messages in the dropdown allow me to quickly address their frustrations in an attempt to de-escalate the conversation. The system is suggesting that I propose some options for a resolution in order to get the conversation back on track. So here I can edit the message to include some of the ideas that I have for them, which may include a payment plan. This way, the disputants can start to reconsider their options and reach an agreeable solution that works for both of them. So I've re-logged on to the AIDR dashboard to check in on my case statuses and if I have any new messages. I can see that I don't have any new messages for the case Nikki Green versus Rent to Own, and that I've been prompted to check on the case because neither party has messaged in the chat for more than 48 hours. Based on how I've handled this case in the past few days, I know that I've sent a settlement agreement for them to review and sign, and that the plaintiff has signed. It seems that the defendant has not signed and also has not sent any messages in the chat, despite my several warnings that I've sent. So the appropriate way to handle this would be to go to my suggested messages dropdown. And since the allotted time for ODR is over, I have to conclude this session. So the system has detected that and suggests that I send this message warning them that I have to conclude the ODR chat and to thank them for participating. I can also send them an additional message noting that the ODR session will be closed and they won't have access to the messages or documents, and instructions for how to access any signed documents.
Okay, so let me I just get back to my talk and just make the sort of final, the last few slides. I think I'm back to.
Yes, we can see the presentation now.
Okay, I have, when I presented this work previously, actually not in which I haven't in such a public forum as this one. Nevertheless, some questions were raised, and I thought I would just bring them up ahead of time for discussion if anybody has any comments about this or thoughts about it. So one of them is, well, okay, does this model actually improve facilitation? Does it really, even assuming that my claims about our ability to predict what facilitators are going to say, and also detecting that there's conflicts and that times have run out, other things, does it actually help the process? So there's only one way to determine that, and that's to actually have a field test of it to see, well, for one thing, does it improve the efficiency, usability, error rate, and satisfaction of facilitators? When we demonstrated this for facilitators, they expressed the opinion that it would, but the only way you can tell is to actually test it. How about the ultimate objective, which is to reduce the rate of disputants default, satisfaction, reduce the time to resolution, so forth? I don't know. It's an empirical question that needs to be tested. So, here's another question. So how does this approach dialects in multiple languages? I would think that in India, this would be a particularly severe problem, but it's a problem other places as well. In Canada, you know, you have French and English. In the United States, you have Spanish and English and others as well. There's also African American vernacular English, which is a little bit different. So how does this approach work in those situations? Well, and good news, bad news, I guess. The bad news is that these models are language specific, of course. The good news is that they're trained on examples. So if you have sufficient linguistic resources and you also have a training set, then you can adapt it to different languages. What would we need for an operational evaluation? Well, we need an institutional partner, which we don't have right now. How can we improve its accuracy? And I have absolutely no doubt that we could improve its accuracy if we added more training data, if we fine-tuned model parameters. So basically, this, you know, there wasn't a giant effort. It was kind of a research project, and so we just had to make some choices about each of these machine learning and HLT parameters if another researcher could take the same data and optimize it. Another thing that I wished we could have done but didn't have the resources for is to have a somewhat finer grained model that includes the negotiation terms themselves. So in the demo you saw, basically, we saw that the system would detect that this would be a good time for one of the disputants to, you know, to suggest some payment terms or something. But what we don't have right now, this discourse model doesn't distinguish among the issues is the underlying liability, the amount, payment schedule, so forth. In this particular area, where in small claims court in the United States, so many cases are basically sort of money lenders or small businesses suing individuals. So these cases are quite stereotyped. There's also quite burdensome. So in that case, you could really imagine developing such a model, since this discourse is so routine. Let's see, what other kinds of aspects of law could benefit from discourse-based approach? Well, I think getting facts from self-represented litigants I think is going to be the place with the biggest return for this model of analyzing the way people actually speak, as opposed to sort of legalese. Okay, so I will summarize. facilitation is a bottleneck for ODR. What this project has shown is that you can model the behavior of facilitators using this multidisciplinary approach that uses human-centered engineering, that is human factors, to model a discourse using HLT and corpus analysis and machine learning to make predictive models over that discourse representation, and then finally circling back and using human-centered engineering to design a tool to present that information usefully. And I would conclude by saying that this is it's a working prototype, but it's not a deployed system. It really is an existence proof for facilitator modeling that we hope is going to stimulate more research in this area. And we certainly are interested in forming a partnership to sort of try it out in the field. And that's my presentation. Thank you very much for your patience in listening to it, and I'd be happy to answer any questions.
Thanks once again, Dr. Branting, for your wonderful talk. If anyone have any questions from the attendees, they can write it in the Q&A session, and panelists can ask questions by unmuting them.
Yeah, so maybe I'll ask one question.
Yes,
so,
please.
Hi, Karl. Thanks for the wonderful talk. So if I understand correctly, so if you can go back to the tables of the precision and recall, so I guess that it's a classification task by which you have evaluated these models, right? I mean, so what exactly was the task? I did not get that. And then how many classes were there, when you were classifying, or if you are in fact treating this as a classification problem, then how many classes were there?
Yeah, good question. Yeah, and apologies for sort of skating over all these details. And incidentally, this is sometime there's going to, the Journal of AI and Law at some point is going to have a paper that kind of supplies a lot of these details. So it's just in the final stages. But yes, so question number one, is this a classification task? If so, what's being classified? And the answer is yes, it is a classification task. And how many categories are there? So let's start with this first row, which is, should the facilitator act or not? This is at each turn, should the facilitator act or not? So that's a binary classification problem. Right. So there's just two classes. Of course, that's going to make this quite a bit easier. It's also somewhat skewed because facilitators frequently don't respond. Right. Which is one of the reasons. So I'm a big fan of Matthew's correlation coefficient, which is a measure of accuracy that's not quite so sensitive to class skew as F1, although there's no perfect measure. So if you look at MCC, it's not as good, indicating that this high number here is influenced by the class skew. Right. But nevertheless, a coin flip would be 0. And an oracle would be 1. So it's pretty decent prediction of action or not. Yeah. All right, so discourse state, that's those kind of broad, like there's about 8 categories or so. Like, is this an introduction, or are we arguing, or we reached a conclusion, or is it an impasse or something? Right. So the accuracy is lower, especially if you look at the MCC. There's a lot of, so 8 classes, that's a lot. Right. Speech acts, that's stuff like, do I introduce myself, or do I say you all should refocus, or do I say looks like we've reached a conclusion? Yeah. So there's 25 of those. Okay. And so a pretty decent accuracy. One of the, we don't calculate the MCC for this is because a single utterance can have more than one speech act. It happens routinely that somebody will say, they'll just have a run-on sentence. They'll just put an and. Yeah. And so there's this whole issue of do I want to segment it by clause, and then classify each one separately. Does that answer your question? I mean, that's a good question. And
it does. It does.
And it's sort of back up to this. It's like when the defendant says something, and also there's this whole history of stuff that people said, is utterances. And now I figure out this bunch of discourse features, which is how many turns have there been? What's the sentiment? What's the vector embedding of this sentence right here? So it's a big laundry list of features. We didn't have the time to sort of really sort of shake down which were most predictive. That would be an interesting thing, but it was like we had this limited budget.
I mean, thanks for explaining it in details. So you mentioned about speech acts, and there were something like 25 of them. So I guess that the speech acts is something that is, they have some dependence on the domain that you are dealing with, right? I mean, totally. Here mainly we are dealing with disputes related to money and finance, and then, but then, if there is a different domain, I guess, because in this case, a particular class could be like asking a probing question. So that makes sense for this domain. So I'm wondering that, if the domain is radically different, say I'm dealing with facilitating criminal cases that are not related to money laundering, say, for example, but so something more serious than that. So in that case, the speech acts could be significantly different, isn't it?
Well, I don't know. Once again, that seems like an empirical question. To me, it seems like the facilitation, the speech acts should be pretty similar, because the process is pretty similar, and the facilitator doesn't get to talk about the domain. That's the thing. The disputants, they can argue about, did you countersign this check, or was the I-beam rusty, or was it tainted or something? They can talk about that stuff, but the facilitator doesn't really do that. And that's one distinction from mediation. So a good bit of the AI work, so it's kind of AI as applied to ODR. So there's been work by people like John Zalesnikov and others that kind of focuses on mediation in the sense of like generating proposals. He's looked a lot at like marital division of assets. Cool stuff. But what we were looking at is we have these thousands, we have these thousands of disputes, and we cannot model everything that goes on in there. You look at these disputes, and people are talking about, anything, and we have no. So the question is, can we do something useful to help facilitators without having to have a model of everything? Or without limiting ourselves to just a single domain, which, like I said, marital assets, great. Criminal disputes, great. I mean, it'd be cool to make a facilitator for criminal pleas, say. But that is not what we were looking at. So the idea, I know in the United States, there is a crisis basically in small claims that poor people get sued like crazy, and they don't go to court. There's a default. And can we help that in this very general way? And the lesson that I would hope that you would take away is that if you get kind of computational linguists and human factors people to work together to study this data, you can do this really new thing, which is make this model of the routine things that people do. And then build predictive systems that operate in it.
Thank you.
So I think there's a lot of possibilities. When I presented this other places, people said, that conflict detection, that would be useful. We have these online forums, and we'd like to detect conflict. And well, strangely enough, that's like the easiest thing. I mean, you can use pretty standard. I mean, that's what we found. You can use fairly standard sentiment detection, and you can see when people are starting to call each other names, say, or when things are ceasing to work well. You can detect that. You don't need a model for that. really. You just need whatever, and maybe in whatever language you have, you just need your basic sentiment detection machinery to detect, to do that. Somebody's asking a question who's muted.
Carl, can you hear me okay? It's Doug Ward.
Oh, yeah. Hi, Doug.
I really enjoyed the talk. Let me ask a couple of questions about where this might go wrong. So you said that there was some problem with perhaps the rich get richer here, that there's some bias in favor of people that are better at manipulating the system. Is it possible your system will learn to help the rich get even richer?
Well, you know,
that the facilitator will find it easier to slant things in favor of the powerful, because it will help to lead to a resolution. The powerful are better at this. They've been around the block a few more times.
Oh, okay. I think the quick answer to that is yes, it certainly is possible. That it absolutely could happen, because there is still a power disparity that the person, let me give you an example. A typical thing is somebody is, I don't know, you know, they've missed payments on their Winnebago, someplace in Utah, and it's like they don't know what to do in court. They don't know what they're supposed to do, and you know, the dealer is going to repossess it. And so they show up online, and the dealer does this all day long. They don't need an attorney because it's a simple process. So it's not like this is an automatic normalizer. It is not. Well, also people have pointed out to me in the legal aid world that, well, not everybody has a computer. Not everybody, people don't necessarily get the notices that they're supposed to, you know, participate. One of the things the system does is it detects when somebody hasn't been engaged, and then lets them know that they're done because they haven't responded. And that's a place people who are less experienced with computers are at a disadvantage. So it's not a panacea. And I think what you raised is, it's possible. Yeah, and then there's, I guess, the horrible possibility that you suggest is that the model itself
Makes it worse.
Yeah, is going to be learning the things that the way that facilitators help the people with money, you know, smooth the way to taking advantage of people who don't.
Let me ask you another question. You say that this is going to help me if I'm a facilitator, but of course, this is very reminiscent of the sort of analytics we put on help desks. And in those cases, one of the things we want to do is fire the people who aren't very efficient, and retrain the people who are salvageable, and reward the people who are doing really well. Did you run into any concerns at all among the facilitators that this has two uses? One is helping them, and the other is helping their boss.
No, I have to say the Utah facilitators are all volunteers.
Okay.
And so the way it works is that they usually work at night after work. They go and log into all these systems, all these disputes, and they catch up with them. And so from that point, getting back up to speed, like for example, having some alerts telling you what's going on and are there, you know, prioritizing them, it just makes their life easier. So no, I mean, these are certainly really interesting questions. I don't know about facilitators' bosses. So I'm not honestly an expert in ODR systems. When I presented this at the University of Montreal, people said, "Oh well, facilitators are super expensive." And that's why people can't do this, is because they're like contractors. They're like, you know, you hire somebody to help you through this thing and it costs an arm and a leg. Well, I didn't know that. What I was looking at in the context of Utah, I thought you scale up to every single county in Utah and there will not be enough facilitators. You know, it's not a completely trivial thing to do. And, you know, even if it's a culture of volunteerism or something, you're still going to have an awful lot of trouble getting enough people to handle every small claim court case in Utah. But thank you. Those are, you know, that's a very good question. I'll add that. I'll add that to my list of good questions people have asked me that I'm not going to dodge ahead of time, because, you know, what I would like is for this approach to be used other places. Yeah, and I mean the unfortunate truth is that this was developed with the idea that Utah was going to use it, but as so often happens, the technology advocate on the Utah Supreme Court, he retired during the course of this project, and you know, the kind of emphasis of that institution has changed slightly. So we're sort of in the business of trying to find other partners who would be interested in this general kind of approach. And it's not like you can just shrink wrap a system like this, because it has this training component. So you really need to have some access to the library of, you know, of cases that somebody's had before, and there's a whole issue of trust, you know, for them to do that. So there's some real cart and horse problems in getting this to go forward. But anyway, I hope people will say, if we engage with human-centered engineers, we can you know, combine, you know, this cognitive task analysis with HLT and come up with this kind of new thing.
Very good. Thanks so much.
Yeah, well, thank you.
So thank you, everyone. I think we are running out of time, so I am pasting here the link for our next private session for the panelists, for all of the panelists, and then we are closing the session over here. I hope everyone joins the link that I have sent in the chat. Thank you. Thanks once again, Karl.
Thank you.